Happy New Year. Welcome to your first edition of The Point of View for the year 2021. We wish you good health and good luck in what promises to be a very exciting year for Ghana. My name is Bernard Avle, your host for this exciting conversation on The Point of View. Tonight we start a series of programs counting us down, not just to the swearing of the president and also determining the matters in Parliament, but really to look at how our politics is going to be. We have a big show for you. It's been a very busy day in court. And tonight we're going to break down all the key legal issues. Point of View is live and interactive. Send us your comments on the WhatsApp number on the screen. If you're watching on any of the social media platforms, please get in touch. We're happy to read your comments. We'll be right back with the program. So it's almost a month since we voted in the December 7 election, and there are still a few issues to be determined, particularly on the parliamentary side. Today was a very busy day in three courts. One court in Hohoe, the other in Accra, the other in Cape Coast. So what are the issues? Well, the NDC and MPP have taken their parliamentary fight to various courts. The first case involves John Peter Amewu. He is the Member of Parliament elect for Hohoe. There's an injunction on his gazetting. That gazetting was done. The Attorney General has joined the case asking for that injunction to be removed. We'll talk about that on the show tonight. There's also the case of Asin North, where James Jachi Kwanson, who's the NDC MP elect for that constituency, is being challenged by some people in the constituency. They say he held dual citizenship as at the time he filed his nomination for the MPP primaries. Therefore, he's ineligible to be MP. We'll talk about that too. And then we come back to Oti region, where Kofi Adams is also facing some issues because some people went to a Hohoe court today to say he was not properly elected because people from the South region were not allowed to vote in that parliamentary election. So if all these three cases are successful, Adam, Peter, James, and John will not be in Parliament. Kofi Adams, John Peter Amewu, and James Kwanson will not get into Parliament. Let's give you a quick summary of what we saw in court today. Bobi Osei brought a quick report to us during the CNR program an hour ago.
It's been almost a month since Ghanaians went to the polls on December 7th. Now, in the aftermath of that exercise, there have been a number of court cases. Now, in today's edition of the Citi Newsroom, we will be putting the spotlight on two of such court cases. Now, in the Supreme Court, we have the state challenging the injunction placed on the swearing-in of the MP-elect for the Hohoe constituency, John Peter Amewu. And also, in the Circuit Court, we have a case brought by the state against 20 MPs that marched onto the Electoral Commission to present a petition against the parliamentary polls as well as the presidential polls, specifically the polls in Techiman South constituency. My name is Bobi Osei and you're welcome to the Citi Newsroom. So after 4 hours of proceedings at the Supreme Court, representatives, including lawyers of various parties to the case involving the state challenging the injunction placed by the whole High Court on MP-elect for Hohoe, John Peter Amewu, have all stepped out of the courtroom. Now, they are joined or followed by their various entourages. Now, we did try to get interviews with the various parties, including Chachu Chikata, who represents residents of Sancho, Kofi, Akpafu, Likpe, and Lulubi. We also tried to engage with Deputy Attorney General Godfred Dami, who is leading the case for the state. He also said he will not speak, but will wait for judgment on the 5th of January. We did, however, catch up with the General Secretary of the New Patriotic Party, and he essentially had some words to share with us as he believes that he is a stakeholder to this particular case.
I'm an interested party. I'm the General Secretary for the New Patriotic Party, and if there is any court action that is likely to affect my legally elected parliamentary candidate elect representing Hohoe constituency, I must be interested, and I am interested.
But you, as a party, did not seem to take interest in this when it started. The
person went as party. They went as party. How will I know that people are conspiring to deny a legally elected member of parliament his right to represent Hohoe constituency? How am I going to know?
So today, the Apex Court of the land saw a Deputy Attorney General, Godfred Odami, continuing with their calls for the injunction granted by the whole High Court against the gazetting of the MP-elect for Hohoe constituency, that is John Peter Amewo. Now, a number of things transpired in court today, and we have here with us our court correspondent, Fred Tetejabano, to break it down for us. What essentially transpired today?
Yeah, so when the case was called this morning, lawyers for the residents of Sao and the lead lawyer, Chachuchi Kata, raised a preliminary objection. His objection was that he didn't want one of the empaneled justices here in this case to remain as part of the panel to hear this case. This judge is Justice Clemens Onyenuga. It was the case of Chachuchi Kata that Clemens Onyenuga had a long-standing relationship and friendship with the MP-elect for Hohoe, John Peter Amewo. And because of this standing relationship and friendship, it could lead to some sort of bias and in him taking a decision or making a decision in this matter. The Supreme Court asked that what was his basis for this particular argument. And he said that they had evidence through people and the fact that Mr. John Peter Amewo himself had made comments initially talking about how close he was with Justice Onyenuga. The AG, or Deputy AG, who was representing the state, also objected to the objection by the lawyers for the residents of Sao. According to him, this particular claim or allegation had no basis. Hence, they didn't see why they should allow Justice Onyenuga to recuse himself or be removed as part of the panel. The panel decided to take a short break. They went into chambers. They discussed it. After about 30 minutes, they returned to court and made the argument that they were dismissing that particular objection raised by Chachuchi Kata because according to them, it lacked merit and that he couldn't establish that relationship he was talking about. After this, the case actually moved on to the substantive matter, why the court sat today, which was the state asking for the injunction placed on John Peter Amewo by the High Court in Ho to be quashed. The state's lawyers, led by the Deputy AG Godfred Adame, made very interesting arguments. One of their arguments was that the procedure in which the lawyers for the residents of the Sao district went to court was wrong. According to him, they should have gone with a petition because this is an election matter, but rather went using the human rights application mode, which they believe that was wrong, procedurally wrong, because the laws, according to them, states that you should go through a petition if it has to do with election issues. He also raised the concerns of something they called human rights, whether they really even had any human rights concerns. He argued that he didn't believe that the residents of Sao had any human rights concern because, according to him, if you look at where they belong to the Sao district, which is in the Oti region. The Hohoe constituency is within the Volta region, and per the laws in our constitution, you can't have somebody, people belonging to a different region coming into another constituency which belongs to another region. Hence, they do not even have any grounding on coming for any human rights case. In his response to some of the concerns or the arguments raised by the AG, Chachuchi Kata, who represented the people of Sao, said that he believed that his client's rights to fundamental human rights have been breached, the rights to administrative justice have been breached, and the right to equality before the law has also been breached. He further stated that he believed that the EC in itself, the CI 128, which they used to govern the elections, was unconstitutional, saying that this CI 128, once it was placed before Parliament, had to be published in the Gazette the day it was placed before Parliament. This was not done, according to Mr. Chikata. Hence, the entire CI was unconstitutional. After the court heard the two sides make their argument, the court set tomorrow, which is the 5th of January 2021, to give a ruling on this particular matter. So we are waiting for the court to give the ruling tomorrow at 12 p.m.
Right. Thank you so very much. There you have it, a very in-depth breakdown of what transpired at the Supreme Court today. About 20 or so members of parliament belonging to the minority side were expected to appear in response to charges by the state at Accra Circuit Court 11. But from what we are picking up, none of the MPs showed up. I'm being joined by our court correspondent, Sixtus Dongulu. What transpired today?
The state charged the members of parliament and a deputy.
So that was Bobi Osei's report, initially speaking to Fred Jabano on all the key cases. The second case Sixtus was reporting on is not really our focus tonight, although we can spend some time on it. So there are three issues here. The first one has to do with the case brought against the election of John Peter Amewu. Indeed, the residents of SAL had asked that his election not be gazetted. We are told that Mr. Amewu has already registered in Parliament. In fact, today I was in Parliament, and we've seen some of the MPs elect go and register, presumably ahead of their swearing in on Thursday. Justice Sai is a law lecturer at Gimpa. Let's talk to him about what he understands about this SAL issue. Now, incidentally, this case is connected to another case. Today, the MPP went to a court in Hohwe to also ask for a declaration that Mr. Kofi Adams was not properly elected as MP, because these 13 electoral areas which voted for presidential election in Buem were supposed to have voted in Hohwe, according to those who took Peter Amewu to court. It's a bit confusing. Let's start with Justice Sai to give us his own breakdown. Justice, thanks for joining us. Good evening and welcome to The Point of View.
Good evening, Bernard, and thanks for having me.
It's been a very busy day for you lawyers. We finished voting, but it looks like the lawyers want to determine who goes into Parliament. What do you make of the Peter Amewu case generally? Because our reporter is telling us that now we are waiting for judgment tomorrow. I'm sure you are also aware that there's a separate case there. Some people have brought against the NDC MP for Buem and the EC on Mr. Kofi Adams' election. We know that Buem and Hohwe are coterminous constituencies. What is your understanding of how the two cases are related?
Well, the two cases seem to be tied to a very surprising legislation which was brought up in courts, in the Supreme Court today. The legislation seems to, the legislation, if it is held to be constitutional, seems to suggest that, contrary to what we all have been aware of, we all know, and the EC also knows, the people of the Seoul area, that is the Central Kofi, Akwafu, Lolobi, and Lipe area, have actually been added to the Buem constituency. Now, if you recall, the case against the case in the whole High Court on the Hohwe constituency was that the EC issued a particular press statement on the eve of the election, which said that the people of the South area will not be having the opportunity to elect an MP. And that was based on the understanding at the time that they were supposed to be part of Hohwe constituency, but will not be allowed to vote in that constituency. Now, in the Supreme Court over the weekend, any general what we call a supplement in which he attached a particular, CI called CI 128, and according to the 128, these four traditional areas are Buem constituency. What this means now is that if the CI is held to be correct or to be constitutional, then the issue of denial of votes will shift from Hohwe to the Buem constituency. But if it is held not to be constitutional, then it means that the issue of denial of votes would now be limited only to Hohwe. One thing that comes up from all this is that both the NPP, the NDC, and to a very large extent the Electoral Commission seem to agree that the people who fall within these four traditional areas were denied their right to vote. So there seems to be some level of admission on the part of the Attorney General, on the part of the NDC, and on the part of the NPP that not allowing the people in those traditional areas to vote is a violation of their rights. The only question left now is where, in other words, which constituency suffers this damage. So while the NPP NPP are moving to Buem to nullify Buem, the NDC are also in Hohoe to nullify Hohoe, all on the same principle that you did not allow the people to vote. Now, today in the Supreme Court, a very interesting argument came up from Senior Chachuchikata, who attacked the said CI on the grounds that every CI, according to the Constitution Article 11.7, is supposed to be laid before Parliament and gazetted on the day that it was laid before Parliament. What was submitted?
Okay, so we're having some challenge with Justice Sai explaining to us the relationship between the two cases. So let's summarize what we know so far while we get him back. So a couple of weeks ago, the Chachuchikata represented some people from 13 electoral areas falling within 4 communities who say that they were originally to have voted in the Hohoe constituency in the parliamentary election, in the election that voted Mr. Peter Mewu as MP for Hohoe. This is the place where Margaret Kweku was the NDC candidate. Now, apparently, the CI the EC had put in place had created a new district called the Guan district. And this Guan district is in the Oti region. So on the 7th of, before the 7th of December, the EC then said the people in those 4 communities, which would be in the Guan district, 17,000 voters, could vote in the presidential election in Buem and then wait for their constituency to be formed out of the Guan district, and then they will choose their member of parliament. So they said Mr. Peter Mewu was not validly elected because these people from these electoral areas were to have been allowed to vote in the Hohoe constituency, and they were not allowed to vote. They actually contend that if you add the number of voters in these 4 districts to the total number of voters in the Hohoe constituency, they believe that could have overturned the result. And therefore, this type of gerrymandering means that Mr. Mewu was not validly elected. Now, this case, the Attorney General went to court, essentially asking that the injunction that was granted by this court be overturned. Now, Mr. Chachuchikata then went to saving the matter, which was then presented to the Supreme Court on this Attorney General's injunction, should not be heard by the group of Supreme Court judges, particularly Justice Honyaga, who he believes was biased towards Mr. Mewu. Today, the MPP went to court to say that Kofi Adams, who was elected MP for Buem, and Buem is adjacent to Hohoe, where these 4 districts, Santo Kofi Akpafololobi and Likpe, where these voters voted in presidential, they are saying that Mr. Kofi Adams was not validly elected because there was no, the 4 communities voters were not allowed to vote in the Buem parliamentary election. They were made to vote for presidential in Buem. So why not parliamentary in Buem? So NDC says Amewu was not validly elected because people in these 4 communities did not vote or were not allowed to vote. MPP says Kofi Adams was not validly elected because people in these same communities, this same 17,000 voters, were not allowed to vote in the parliamentary election in Buem. So this is the situation. The same group of voters, 2 groups of people are fighting for. MPP said they should have been allowed to vote in Buem. So Kofi Adams didn't win because if they had voted, they believe the results would have been different. NDC says, well, Amewu did not win because if these guys had voted in Hohoe, Amewu would not have won. This is where we are, and which is what Justice is saying, that it looks like NDC, MPP, and EC are all agreeing that the people in these 4 communities were denied the right to vote. Now, what in the parliamentary election, what is left is which place they were supposed to have voted. So Justice, if you are there, this is pretty interesting. Now, do you not think that then these 2 cases ought to be determined together then? Because if the original case against the election and the gazetting of Amewu is heard and the judgment is delivered tomorrow, that would obviously have implications on the MPP case against Kofi Adams, because it's the same group of voters we are talking about, right? So, I mean, in normal life, this should have been a case held together, right?
Yes, not exactly, because there's another twist. You know, the case before the Supreme Court is supposed to determine whether the High Court in Bo has jurisdiction to hear this matter on the grounds that the case was filed as a human rights action, and the Attorney General is saying that this is a case which is an election petition and not a human rights action. Therefore, the Supreme Court should, actually strike down the case and restrain the judge in whole from hearing, the matter. This is the issue before the Supreme Court. Now, this is the trick. If the Supreme Court limits itself to this particular issue only, then it means that it will not make any pronouncement on the constitutionality of the CI 128, which is now the core of these two cases. And now, and the other side is that usually courts would like to do just what is brought before them, because technically speaking, this issue of CI 127, the CI, which is the fulcrum of this, is actually supposed to be a defense to the case, the whole court, and not a sword it's supposed to be a shield in the case in the whole court and not a sword in the Supreme Court. So it is likely that the Supreme Court may not make a pronouncement on the constitutionality of the CI, at least in this matter, if we want to just limit itself, because as of now, the Supreme Court, technically speaking, is not aware of what is happening in Guem, because that matter is not before it. The only issue before it is whether the High Court in Go has jurisdiction, and that issue could actually be resolved without recourse to the constitutionality of these CI.
Okay. But Justice, assuming the Supreme Court decides to adjudicate and rule on the constitutionality of the CI, that will have implications on the case in Hohwe, because if the CI is valid and constitutional, it affects the Kofi Adams case. If it's not, it affects the Kofi Adams case.
Precisely.
Right?
Precisely. If the Supreme Court makes a pronouncement on the constitutionality, definitely the High Court in Hohwe could rely on it. And of course, I'm sure the counsel in the case will advert the judge's mind to it to decide to use it in ruling in the Kofi Adams case.
And so let's assume the CI is considered constitutional. That then means that Kofi Adams may be in trouble, right? Because because once the CI is valid, go ahead.
Again, the CI may not be the only issue before the Hohwe Court. So it's a complex matter. If the CI the validity of the CI was the only issue before the Hohwe Court, then we could say that then the proposition you are making would apply. But if it ends up not being the only issue, then it means another issue can actually override the CI issue. So, for example, if you said the CI is constitutional, they can also say that, well, then what you actually, Kofi Adams can also file another defense to say that the issue you have brought as an election petition is actually a human rights issue, which case the procedure you have adopted cannot hold. So all the arguments in the two cases can apply, across each other.
So it's going to be a complicated one, but certainly we are looking forward to listening to what happens tomorrow, because that will be.
And let me just draw attention to this. I think today one interesting thing came up in court where the judge, the Supreme Court actually reiterated the point that journalists who would wish to have, the process going on, the election, hearing going on could apply. This came up along the way when the court tried to warn journalists from recording the proceedings. And Mr. Chikata, drew the court attention and made a forceful argument that these are cases that are of high public interest. And if the court would advert to the CI, which was passed to allow the court to have these things broadcast. And the court actually reiterated the point that, yes, so long as a journalist applies, they may be able to, or they may grant that leave to be. So I would suggest that you would probably
put an application, okay.
Put an application to get to see what will happen tomorrow in court.
So what happens in tomorrow? Would it be final, or that is tomorrow preliminary? I.e., don't forget there was a case about gazetting Mr. Mewu's victory, and the Attorney General has gone to say that this court did not have the jurisdiction. it will appear to me as though this is not actually the substantive issue, and that even after tomorrow, the main issue will then come up. Is that correct?
Yes, two things may happen after tomorrow. If the court decides that the High Court in Ho does not have jurisdiction to hear this matter, that will end the case in its entirety. However, if the court decides that the High Court in Ho has jurisdiction to hear the matter, it means that then all the parties would have to pack baggage and march to Ho to continue the substantive matter. So whichever way, it appears that there's still a 50-50 chance for the case to survive beyond tomorrow, or for the case to end tomorrow.
Fair enough. Thank you. We'll still come back to you. This is the point of view. So tonight is in a court issues, 3 court cases. John Peter Amewu is waiting with bated breath for what happens in the Supreme Court tomorrow. Kofi Adams is also waiting for what's going to happen in the Hohwe Court. But there's also James. So it's Peter, James, and John. James Jachi Kwesen is the NDC MP elect for Asin North. Now, some people have gone to court to say that at the time he filed his nomination as the MPP candidate, he held a dual citizenship. So he also has violated the law. So in all these cases, the MP elect and the EC are the respondents. We'll come back and look at that and other issues. This is the point of view. Stay with us. Welcome back to The Point of View. This is our first show for the year 2021, and tonight we're getting into court. Very busy day in court. In fact, apart from the 3 cases we mentioned, if you listen to the report that will be also filed, there's also another one where 20 NDC MPs had been named as having been served with some invitation to go to court. Well, the MPs led by Haruna Idrisu say they are not going to court because they haven't been properly served, and that even though they are law-abiding, they didn't think this was the right way to be served. Now, this happened after they had marched to the EC to present a petition, which march the EC considered an unlawful protest. So that issue is also up for discussion. Now, we're expecting to get lawyer Yaw Oppong to bring us his perspectives on this. We've not put him on the line yet. We've not been able to reach him. But we have Justice Sai, and we thank him for staying with us. Now, Justice, this is interesting. So apart from the Peter Amewu for Hohwe and Kofi Adams for Boem, James Jachi Kwesen is the NDC MP elect for Asin North. We understand some people in the constituency are also claiming that he was not properly, that's a different, they're essentially saying at the time he filed his nomination to be parliamentary candidate, he had not renounced his Canadian citizenship, and therefore, since the process of becoming an MP begins from the time you file your nomination, he consequently has breached, or the EC in admitting him into the race has breached the fundamental law. How different is this matter from the other one we are looking at? And what's your reading of this situation? Is this also a petition, or this is a human rights case?
Yeah, thank you. So this matter is quite different from the first 2 in the sense that this has to do with the qualification of the person who has been elected as the MP, while the others have to do with the right of the people to vote in the election. So really, this is a proper election petition, election petition properly so called. Now, the question of eligibility is very important because it is not just important when you are filing, but also when you have won and actually when you are sitting in Parliament. In fact, in other cases, you could have actually served the entire period and your eligibility in the previous, after you have left office, will still be impeached, and the situation will end up being that you have never been an MP. So it's a very critical, important matter. Now, the question I see from this case is that, there is no doubt that if you hold a dual citizenship, you cannot be a member of Parliament. We may question the value or the quality of that law, but I think as for now, that is the position of the law. The question I see in this case is, at what point in time do we say that a person has revoked or renounced his citizenship? Is it when he has undertaken the process of renunciation? Because renunciation is a series of events. So from the time of applying to renounce the time it has been renouncing, and the time of issuing the certificate. So these are different stages. So the question that probably will come before the court is, at what point in time do we say that the person has revoked? From what I have been reliably informed on the case, it appears the MP-elect is saying that he has actually done the revocation, just that the certificate which should have been issued had delayed because of, has delayed. Let me not say more, has delayed. So the judge would have to determine probably at what point in time do we say the revocation was done. If it was done at the time he made application, then it means that the revocation took place even before the certificate was issued. If revocation is deemed to be done at the time you actually, sign those other documents, then fine. Because let me bring in an analogy. We are aware that to be able to get admission into a university, you should have, you should have completed your SSC, and we know there are instances where, or to apply for master's program, you should have had your first degree. And we know that there are instances where, some schools or schools generally will admit you, and knowing very well that you have completed the course in substance, just that the process of certification, which usually takes more than, sometimes a whole year to come. So, example, if you're in the UK system, for instance, you will complete and the certificate is likely to come the following year, or you actually graduate the following year. But that notwithstanding, some universities will admit you into their program, pen with your transcripts or some other evidence of you having completed and then pending. So that is based on the principle that they focus on the substance of your completion than they will focus on which is the certification, the formal issue of the certificate. So this is one of the questions that maybe the judge would have to consider in resolving this matter. But just, if the judge concludes that as at the time,
if the judge concludes that as at the time the guy filed his nomination, he hadn't renounced his citizenship, then it's a straightforward law, right?
Yeah, if he has not renounced it, then it means that he was still, because we already know, I think the authorities, recently we've had a situation like that where the court said that the time of the critical time is the time of filing nomination. And that is so because it is when you are filing the nomination that you actually make a declaration that you are eligible. So if at the point of making the so it's basically an offense of deceiving a public officer or perjury, lying under oath. Because on the EC's form, you should have stated that you are eligible, you met all the criteria on the eligibility list. So it's actually a question of you lying to a public officer or lying under oath.
So you're saying that what could save the MP is if he had actually revoked, but the certificate had not been sent. So the material issue is the time of the revocation, not the issuance of the certificate. That would be the issue the court is looking at.
I think that would be the issue that the court would decide if the facts we are dealing with is the same as the fact that the court is dealing with.
But there's a precedent here where a few years ago, Mahama Yariga went to court on Alhaji Dramani Sakande for Boku Central, when we understand that in that case, he had a dual citizenship. And we actually understand he was jailed for that. So it's not a simple issue of his declaration of being MP-elect. There are further issues beyond that.
Indeed. So it is you will be removed from Parliament for not being eligible, and then you face charges of usually perjury or lying under oath.
Wow.
And if that is also found, if you are found guilty, you will be actually jailed. So it is not it's not simply a matter of you leaving Parliament and saying bye bye. No, you stand to be jailed.
Now, is it not interesting that with all the brouhaha about election that we just held, the three cases we are discussing have nothing to do with the conduct of the election necessarily, whether the votes were counted properly or numbers recorded. But it seems as if we are looking at procedural, administrative, legislative, and that type of thing. This sounds a bit extraordinary, because I would have thought that cases around whether the vote was properly counted, whether the right number of votes were allocated, would be what would preoccupy political parties. But it looks like we are rather seeking solace in administrative and procedural issues. How surprising is that?
Yes, it is not surprising to me, because I think this is not the first time eligibility has become an issue in our election. So you just reminded us of Adamu Sakande, his eligibility. At the point, I remember Honorable Judge Mensah faced a similar issue for contesting in a particular constituency where someone challenged him, saying that he does not hail from that constituency nor reside in that constituency. Because it was one constituency which was later divided into two, and he contested in the other one. So these eligibility criteria issues come up, but indeed, you are right when you say we are surprising, also in the sense that we have all believed that the election is about counting, is about voting and all that. It's easier to prove these legal issues than to prove the ones that require recounting and recollation. So those ones require, you need to get more evidence. You need to gather evidence to be able to challenge those ones. And it's too early, considering the fact that the Gazette itself was done not long ago. But the reason why we are rushing, I suspect the lawyers are rushing with these particular ones, are that because of in the numbers in Parliament. So, every seat will come this January. Every single seat will count. So anyone who loses guard for his seat to be taken out would have to suffer the consequence for the 4 years. Because remember, the election of the speaker, which is the important thing now, is by simple majority. However, the speaker's removal is a two-third, you need two-thirds, which no party would get no matter what happens. So it's an opportune time for you to do as much as you can to reduce the number of your opponents. And I think that is what is motivating this style of litigation. It's easy to prove because it's a legal question and it contains legal argument. It doesn't require more than that. So lawyers and their clients seem to be very aware of these facts.
Just finally, today we saw Peter Amewu register in Parliament, and we saw a lot of posts say that whilst the matter is pending to be determined tomorrow, he oughtn't have done that registration. Is there any issue there? And then the other question is, these three cases obviously will not terminate before December 6th, the midnight of December 6th, because parliamentarians will be sworn in anyhow. Does that give any injury to the applicants in any of the cases at all?
Well, so it does. It does, to the extent that the election of the MP, the speaker is concerned, it does. Because when you miss out on this opportunity to get the speaker elected, you probably may never have that opportunity until the next parliament. So that is the extent to which the injury will go. But quite apart from this speaker issue, it also, when you take the Saul issue, for instance, it is significant in the sense that you are denying, and I think the population is about 17,000 Ghanaians, a representation in the Speaker of Parliament, in Parliament for the next 4 years. And there are divided views on this, whether it's 4 years or by-election, but I belong to the school of thought that it is for the next 4 years. So that injury is irreparable. In fact, even if you deny them representation on the one of Parliament, it's still an irreparable injury, which is unjust and unfair, because the essence of the democracy we are practicing or we are experimenting is to have representation, and anyone who is not represented in Parliament is, as one philosopher would say, is a slave, because he's then subject to the will of someone other than his own will or the will of his representative. So it is a serious violation. It's actually shameful. To be honest with you, it's shameful that how many years of independence a group of people in this country would have to be ruled by other people without their consent. And that is the extent of the injury. So I think, if possible, something should be done about this situation so that that injury does not even occur to start with.
Thank you so much, Justice Sai. This has been really enlightening. We appreciate your insights on the point of view. I appreciate them. We're still on the point of view. So let me just show you the three men we've been discussing. John Peter Amewu, MP-elect for Hohwe. He will be sitting on tenterhooks waiting for a judgment tomorrow. He won the election. First time MPP would have won a seat in the Volta region. But there are people from 13 electoral areas in 4 communities who say they were disenfranchised. The second person is Kofi Adams, who was sitting in somewhere. These 13 communities or 13 electoral areas were added to his constituency for presidential. And now people in this place say they should have voted for parliamentary as well, and therefore he's in trouble. He's also going to be waiting, listening to the Amewu case to know what that means for him. Then there's James Jachi Kwesen, who's the NDC MP-elect for Asin North. His is about citizenship, and we've been talking to Justice Sai about this. We'll take another quick break. When we come back, we'll wrap up on 2 things. So the NDC minority say they would not honor a Facebook invitation for them to come to the court, having been summoned for what the police consider to be an illegal protest march. And then also the MPP say they have chosen their leadership side. They held a National Council meeting today. And they say they have decided on who will lead them in Parliament. Some very interesting names. I'll share some of the names with you when we come back. This is the point of view. Don't go away. Welcome back to the point of view. So two pieces of information. MPP's National Council held a meeting to decide leadership of Parliament today. And we understand they've proposed Oseche Mensah Bonsu to be retained as majority leader of Parliament. That is, if they will be the majority, because there's still some, in fact, I could ask Justice about this, there's still some confusion about this. MPP has 137 seats, NDC has 137. Now, there's an independent candidate, and we understand, if you read the standing order, it describes the majority leader as the leader of the party or parties which have the majority of members of Parliament. Now, no party has a majority. The NDC as a party has 137. The MPP has 137. Now, Fomena MP, we understand, has said that he is with the MPP, but he is not from a political party. He is the independent member of Parliament for Fomena. So, a simple reading of the standing orders will suggest that there's no majority party. Now, I don't know if Justice Sai, you're still there. I don't know. You are the lawyer here. I went through the standing order today, and it's very clear in defining who a majority leader is. Is the leader of the party or parties with the majority members of Parliament. That's in terms of number. So, today we interviewed the NDC side, and they said they are the majority. MPP have also gone for a meeting, and they say Che Mensah Bonsu will be the majority leader. What's your reading of the standing order and the Constitution? What's going to happen on SID? Is this matter clear, or do you have to go to court on this one too?
Well, the question of majority and minority will not really arise because, as we know, the numbers as they stand should be, equal. So then everyone can call any of the two sides can call themselves majority and all that. But as your definition shows, the standing order shows there will not be any majority and there will not be any minority. However, when it comes to the election of the speaker, as a matter of fact, the question of majority or minority doesn't arise in that context because it is first of all by secret ballot. And secret ballots, whenever parliamentary voting are usually not secret, but the Constitution allows certain processes to be conducted by secret ballot. And those ones, by the fact of that secret ballot is an admission that MPs are allowed to vote by their conscience and not to vote necessarily according to party lines. So it is also possible that you can have majority in Parliament and still not be able to get your speaker through because the MPs are voting by secret ballot and they would have voted for some other person than the one presented by the majority party. So in other words, what will happen on the eve of January 7 is certainly going to be one man, one vote. So MPP may not be sure of putting up a candidate to become the speaker, and NDC may also not be sure. So it's going to, I foresee a situation where each party will propose, a candidate for the speaker's position, and the secret ballot will determine who eventually becomes the speaker of the parliament. Wow.
So on the speakership side, it's about the vote. But MPP issued a statement today. Let me read it.
It's about the vote.
On the leadership of their side, the statement says the New Patriotic Party has, at a National Council meeting held on Monday, January the 4th, elected leaders of its parliamentary group for the 8th Parliament in accordance with Article 140 of the Constitution of the MPP. The leaders of the MPP parliamentary group include, then they mention, Honorable Oseche Mensah Bonsu, MP for Swami constituency, Ashanti, majority leader. Alexander Fenyo Markin, MP, Futu constituency, Central Region, deputy majority leader. And then they go on to name Anodom Prayer, majority chief whip, Idrisu Habib, majority deputy chief whip, and then leader Sarah Malhassan, deputy majority chief whip. Are they being presumptuous in calling them majority since they are not the majority party simpliciter? Or does the fact that the Fomena MP will vote on their side give them a simple majority?
Well, like I said, the Fomena MP doesn't count when it's a question of majority or minority, because if he wants to join any of the parties, he would have to, as we know, resign and contest as on the ticket of that. I think that's what the law tells us. So I see, in all honesty, I see the adjective majority as one of presumptuous, attempt to. We don't know what they have up their sleeves, but really, as it stands by the EC's figures that we have and we are working with, we know that such adjectives could also be used by the NDC, and I'm sure it won't be long when the NDC will also come up with its own leadership and will start calling the majority. And I think it's understandable, because no one wants to be treated as the minority when you are equal. So these things are expected, but in reality, all they are probably trying to say is, this is our leadership this is the leadership of our side of the house, not necessarily, so we can take the majority claim as one of the political innovations that may attend the
But do you foresee this being resolved in court? Parliament is a master of its own procedures. If they can't agree on who will be the majority, Parliament makes laws, judiciary interprets them. We are in uncharted waters at this stage. If the two parties decide that they are not going to back down and both claim to be majority because it's a draw, what's going to happen?
Well, I don't think the rules are such that Parliament cannot function without one side being majority and one side being minority. There are certain committees that are reserved for chairmanship, of which are reserved for majority, and there are some that are reserved for minority. What it means is that those classifications will not work anymore, and in that sense, we expect that the members of Parliament will find a way of, sharing these positions among themselves without necessarily going to court. Well, the court is the Supreme Court is the master of the Constitution, while Parliament is the master of its own rules. What it means is that when there is any conflict as to what should be, the Supreme Court will look at the constitutional provision to determine the constitutionality. And if Parliament can't agree, so long as that disagreement does not affect the provisions of the Constitution, then Parliament can resolve it by its own procedures and other means of diplomacy. And sometimes we seem to see Parliament as a very cantankerous institution where people are always fighting, but that is far from the truth. Most of the time, about 90% of the work of Parliament is done by consensus. About 90%. So it's just that the contentious ones are the ones that attract our eyes and our attention, and they also come to deal with these other issues of appointment, which are publicly known. But for about 90% of the time, they don't vote at all. It's just a consensus issue. But one thing that also comes to the fore is that this time around, the practice of the Speaker asking MPs to vote by saying here, here, nay, nay, will not be very helpful, because if you have an even, a split Parliament, your ears cannot be
to decide who is shouting louder. Fantastic.
So then you need to do a lot of voting and hand head counting than the usual here.
Thank you, Justice. Really insightful talking to you, Justice Sai is a law lecturer at GIMPA.
I think you should make that application to the court to have the proceedings.
Yes, we will do our best to be there so they can help allow us to cover it possibly live. Justice Sai speaking there to us. Thank you very much. And in the last few moments, we just got a story on citynewsroom.com. Albam Gbagben is likely to be named NDC candidate for Speaker of Parliament. So they will vote on Thursday night for either Gbagben or Michael Quay. So we don't know who's going to win. We've been talking about the three cases, Asin North, the Buem constituency, and the Hohwe case, and also just giving you some quick highlights on MPP choosing what they consider to be the majority side who will be their leadership in Parliament. My name is Bernard Avle. I've been having I was supposed to have Yaw Oppong on the program. We couldn't reach him. We apologize for this, but I hope you've had some insightful perspective from our brilliant guest, Justice Sai. Thank you very much for being on the program. We'll see you next time. Happy New Year one more time. Our next show will come to you from Parliament because we'll be covering live the inauguration of the new Parliament as well as the dissolution of the old one. It's going to be exciting. Till then, we'll see you next time. Bye-bye.
Point of View is powered by Airtel Tigo. Airtel Tigo. Life is simple.